Assalamualaikum. My name is Nur Aslinda binti Man Omar. The first issue is whether LSC have the ability to carry the goods. There are three rules of law under Hague Bisbee Rule 1968 that can be applied for this issue. First rule is under Article 3, the carrier is obligated to conduct reasonable care before and throughout the trip. Second is Article 3, Section 1A. Make sure the vessel is seaworthiness. And the third rule is Article 3, Section 1B, which ensures that the ship is adequately staffed, equipped, and supplied. For this issue, LSC had done their duty as stated in Article 3 as they had employed a firm of reputable and reliable repairs to repair their ship, which is the Swan, and delegated the responsibility of making the ship seaworthiness before sailing. Based from the case, the Swan ship was seaworthiness for sailing. There was a negligence from reputable and reliable repairs. For the second cases that involves the Caribbean ship, which is the ship was on fire after loading was complete. LSC again rejected the claim of the cargo owner, arguing that the duty to ensure seaworthiness at the beginning of the voyage was limited. However, according to Hague Bisbee Rule, Article 3, Section 1A and Article 3, Section 1B, it is a responsibility of the LSC to make sure that the ship was seaworthiness in all aspects before and at the start of the sailing. LSC delegation of their obligation to exercise due diligence to make the ship seaworthiness does not imply that they is abdicating their responsibility to provide a seaworthiness ship. Seaworthy of ship is LSC responsibility, and they cannot avoid it by delegating their duty. Moreover, based from the past case, McFadden and Covey Blue Star Line state a ship is not seaworthy if it has a defect, which is prudent owner will have required to be rectified before sending the ship to the sea. Therefore, if the CFC can prove that the fire occurred as a result of LSC fault or negligence to ensure the ship's seaworthiness, LSC do not have the ability to deliver the good.
Hi, my name is Nurul Izzah binti Ahmad. Hi, my name is Nurul Izzah binti Ahmad Bakri, metric number BB191100792. I will explain second issue. Second issue is whether the LSC vessel seaworthy or not when the water enters the ship's hull, causing damage to fresh meat core property. According to Article 31A of Hague Bisbee Rule 1968, state that the carrier are bound to before and at the beginning of the voyage to A. Make the ship is seaworthy and C. The cargo are fit and safe for receiving, carrying and conservation, the whole refrigeration and cool chambers, and any other areas of ship in which the item are carried. In the case of Maury King, cargo owner versus August 1895, the court ruled that the vessel was unfit to sail or unseaworthy because the frozen meat was damaged because there was a defect in the frozen appliance, in example the refrigerator. The LSC ship's hull is where the FMC cargo is stored. Because of the water entering, it has damaged the ship's hull, which is the cargo carrier space in the compartment of the ship. The ship does not fulfill the physical condition of the ship, such as the damage in the part of the ship that causes it to be unseaworthy and not fulfill the requirement as stated in Article 31A. In the case of Maury King, the cargo owner versus August 1895, the defect on the ship has made the ship unfit to sail and unseaworthy. Thus, in the LSC MSC case, the water has entered LSC ship and causes damage to the goods, so the ship is not fulfilling the requirement which is needed to sail. This is because, as they are defect on the ship, they are considered unseaworthy and not unfit to sail. The condition of other part of the ship in which could carry is not fit and safe, as in Article 31C, where the carrier needs to ensure the safety of all the parts of the ship. Moreover, LSC company has hired professional to fix their ship before they sail, but because of the irresponsible attitude of the Sun company in repairing the ship, and the LSC company did not double check the vessel, has caused the damage. Although LSC has diligence in ensuring the ship is seaworthy, but when sailing, the damage has occurred and caused defection to the goods. In conclusion, the ship is not seaworthy when the water enters into the ship's hull that causes damage to FMC goods.
Assalamualaikum, my name is Nur Sahida binti Norman. Number matrix is BB1911006 and I will present for the third and fourth issue. Firstly is whether LSC can reject CFC cargo compensation claims regarding damage to the cargo as a result of fire before the ship sailed. Based on Article 54A1 in Hamburg Rules, where the carrier, the servant of the carrier, or the agents of the carrier are accountable for loss, damage, or failure to deliver due to the fire. In short, LSC is liable when there is damage happen to shippers' goods and cause CFC to take action to claim from LSC company as their cargo completely destroyed as a result from the fire. Moreover, on Article 54A3 mentioned if the plaintiff is claiming a survey should be conducted to look into the cause and circumstances of the fire, and a copy of the report from the surveyor should be provided upon request from the claimant. Thus, if LSC want to reject CFC claims, they need to wait until inspection of the causes of the fire on the ship is done and reported. The fourth issue is whether it is the duty of the LSC to be responsible over damage on CFC before loading or after loading complete. Based on Article 41 under Hamburg Rules 1978, where the duration is longer, and this means that carriers are responsible when they are in charge of goods at the port of loading, during transportation and port of release. It means as long as the goods are still there and have not been delivered to the buyer, it was responsible for carrier. Therefore, if anything happened to the goods while under LSC responsible, they should liable for it. Next, on Article 42A, as of the moment the goods are delivered to the carrier before the goods are loaded onto the ships, this is when the responsibility of the carrier begins. LSC is liable for CFC goods initiated by the seller who send the goods to the carrier before or after they load the goods onto the ship. In conclusion, LSC is responsible because they are the shipping company that's supposed to be responsible for the goods until the goods are delivered to the buyer.
In question B1, the main issue in this situation is whether Samson, the seller, is liable for his employee negligence for setting high temperature that caused some fluid leak from the container. As agreed by both parties, Samson would ship the 200 cartons of codfish and has packed the goods in the container, in the refrigerated container. But his employee carelessly set the temperature higher than required. Green Ltd, the buyer, discovered the goods in bad condition as they are leaked and bad smell from the container when the good is arrived. To advise Samson, there are two sub-issues need to be considered. The first sub-issue is whether Samson has fulfilled his duty as a seller. According to Hindley and Corporation versus East India Produce Corporation, 1973, seller is obligated to send the goods according to the description in the contract. Samson has packed the goods in the refrigerated container, but his employee carelessly set the temperature higher than what is required. The goods shipped, even the temperature is not set as required. In this state, Samson already breached the contract due to do not send the goods as the requirement to pack the goods in specific temperature. The second sub-issue is whether the risk has passed to the buyer, which is Green Ltd. According to the Julia 1949, risk has passed to the buyer when the goods load to the ship. Buyer must take the goods and pay for the price. However, according to Kwei Tek Chow versus British Traders and Shippers 1954, buyer has right to not accept the goods for not following the description as stated in the contract. Besides, the buyer also do not need to pay the goods if it is not conformity, according to Manbre-Sakharin Corporation versus Corn Products Corporation in 1919. In this case, Grain Ltd do not need to pay for the goods as the goods is in bad condition. We know that the good is not in good condition because there are leaks from the container and bad smell happen. This means that the good is not set in the high temperature. This means that the good is not set as requirement in the contract. Based on what happened, the damages is happen before the goods is shipped to the buyer, which is Green Ltd, which means Samson has breached the contract and the risk do not pass to Green Ltd. Samson is liable for breaching the contract and bear the cost for the goods damages. Besides, he will not get paid for the goods.
I'm Norwani binti Arakama with matrix number BB110573. Today I would like to present about the question 2B in International Business Law, which is problem solve based questions. So before I start the further answer, I would like to share the situation given in question 2B, which is Samson agreed to sell 1,500 bottles of olive oil to Hamlet, FOB, London to Denmark, March shipment. Under the contract, Samson agreed to make the shipping arrangement and Alex, a freight forwarding agent, booked shipping space aboard the Polonius, which was due to arrive in March. Unfortunately, the ship did not arrive until 2 April, but the olive oil was then loaded on board and stored on deck. Unfortunately, the olive oil was lost when it was swept overboard in a storm a few days later, and then the olive oil was not insured. So this is where the problem or issue was arise when the olive oil was lost when it was swept overboard in a storm a few days later, and the olive oil was not insured. Hence, whether Samson cancel the contract with Hamlet and give compensation or dealing with agent, which is Alex, according the problem occur. This will be solved by following related contract in this case, which is I will explain more further. So for this case, there will be 2 rules that will be used to solve this case, which is contract of carriage of goods by sea and special provisions, force majeure clause. First of all is contract of carriage of goods by the sea, which is we use bill of lading in section 5 bracket 1. So based on the situation given, that can be seen that the contract of carriage of goods can be applied to solve this problem, because contract of carriage of goods in a contract that made between carrier of goods and consignor or consignee. So where this contract usually define the right, duties and liabilities of parties toward the contract. So this is being used in the term of the situation that Samsung faced, because they made the contract and then make the shipment arrangement. When according to the means of contract itself, that the goods which are the subject of the sale contract are in the charge of the carrier and his agent. The seller may employ a freight forward to make all arrangements for carrier, but the carrier will normally employ a loading broker to obtain cargoes for him. Hence, the seller usually didn't make direct contract of carriage with the carrier, because in this situation, Alex, who freight forwarding agent, was involved. Secondly, Samsung might be blamed because according to Bill of Lading Act 1855, which is in section 5 bracket 1, where the buyer of goods who had obtained the bill of lading from the seller or shipper of the goods could not sue or be sued on the contract of carriage made between the shipper and the carrier, to which he was not privy. This means that the contract carriage of goods usually based on carrier bill of lading, which is made after the goods have been placed on board. So when referred to the meaning of bill of lading itself, it was function as an evidence of the carriage contract, or as a receipt of the goods and document title to the goods. Document title. But unfortunately, in this situation, Samsung didn't mention the document of bill of lading as the evidence after make a shipment arrangement with agent. Hamlet, which is the buyer, cannot use the terms of passing of risk in contract international sales of goods law, which is in Article 66, where loss of or damage to the goods after the risk has passed to the buyer does not discharge him from his obligation to pay the price, unless the loss or damage is due to an act or omission of the seller toward Samsung. So, this contract act, international sales of goods, cannot be used in this situation, because Samsung agree to arrange the shipment, but then the ship didn't arrive in the right time, as they mentioned in the deal of contract. Besides, the goods already loaded and stored on the deck, but the goods were swept overboard in the storm a few days later. So Samsung cannot be sentenced by this act, because the damage is not because of the cost by the seller, but Samsung might not get compensation because he didn't provide a bill of lading document. By look at the first major definition itself, common contract, which to essentially free both parties from liability or obligation when an extraordinary event or circumstance occur beyond the control of the parties, likely external factors such as war, strike, bad weather, volcano, or flood. So from this explanation, it can be seen that when the olive oil was lost when it was swept overboard in a storm a few days later. Hence, it was beyond the control of seller, except the let of shipping. So, the first major clause in a contract become important in this, especially in one of any extent in time. because it cannot be understood as it stands in for a party from an obligation under the contract or suspend that obligation. So, as a result from this situation given, Samson need to give a compensation toward Hamlet and the contract will be invalid. As a result, Samson need to give a compensation toward Hamlet and the contract will be invalid due to the goods condition. But in other words, Samson by mistake didn't include the bill of lading when contract of carriage was made, which is shipment being arranged by him, and Alex will be in fault because he carelessly considered the ship problem, where it's overdue until April, which supposed arrive in March shipment. Then, as for the lost goods, Samson may discuss and explain to other parties using the special provision in international contract, like force majeure clause, because the cause of damage or lost goods is beyond the control of the seller. So the seller will not be falsely for the damage of the goods or loss of olive oil.